All right, it is 12 noon. So we are going to start officially while our attendees continue to roll in. The CLE code for today's tax update is 8206. That is 8206. And I will provide it again toward the end of the presentation. Mark and Chris join us today to cover highlights from the 58th Annual Heckerling Institute on Estate Planning, which was held in January in Orlando earlier this year. So the goal will be this afternoon to talk about some estate planning and tax updates that might affect your practice. So we are excited to have them with us today. Again, the course code is 8206. And I am going to talk a little bit about the upcoming CLE presentations with the tax section of the Florida Bar. There's going to be a CLE on the topic of corporate taxation held on March 13. And Adam Smith will join us for that corporate taxation overview. We do have, of course, the annual meeting, the tax section annual meeting coming up on May 2nd through May 5th. That'll be at Atlantis Paradise Island. And I understand that registration will be open very soon for that. I also want to recognize our tax section sponsor, Jones Lowry, who will join us for our next tax section meeting. But they are sponsors, and so they are sponsors for this CLE presentation. And our attendees numbers are up, so we are good. I'd like to introduce our speakers. Mark Brown concentrates his practice in the area of wills and trust, domicile planning, probate administration, and sophisticated estate and gift tax planning. Mr. Brown practices in Palm Beach County for over 25 years. He earned his bachelor's degree in accounting from State University of New York at Albany and his JD from Duke University School of Law. He's board certified in both tax law and wills, trusts, and estates by the Florida Bar. He's also a licensed certified public accountant, and he is the immediate past chair of the tax section of the Florida Bar. Thank you for joining us today, Mark. Chris Weeg is a board certified tax lawyer and CPA with a focus on tax and estate planning. His practice includes drafting wills, advising on income, gift, and estate tax issues, forming businesses, nonprofit entities, and probate estates. Chris is experienced in preparation of gift and estate tax returns in all phases of estate administration. He's a triple gator. Chris graduated from University of Florida with an accounting degree, a JD, and an LLM in taxation, and is admitted to practice in Florida and Texas, and is also a licensed CPA. I encourage everyone to put their questions in the Q&A box there, should you have any questions come up. And if they happen to be part of or a topic being covered in the presentation, Mark and Chris will answer to the best of their ability, or may decide to answer at the end of the presentation. And with that, I am officially handing the mic over to Chris and Mark. Thank you for joining us today.
Thank you, Jennifer. It's great to be here again doing our annual Heckerling update. I thought it was a fantastic program. And before we get into Heckerling, as immediate past chair of the tax section, like you mentioned, I just have to advertise some of the stuff coming up. The chairs would want me to do that. You mentioned Sean's meeting in the Bahamas is coming up May 2nd to 4th. Registration starting soon, but the room block is still open. So I'm going. For those of you who haven't signed up yet, sign up. It's going to be a great program. So anyway, we're here to get into the Heckerling takeaways. There's a lot of stuff this year. I thought it was another very strong program. Chris, what do you think?
Yeah, this was the second year that we're back in person. What was it? 21 was the COVID year. 22 was the year that it was supposed to be in person, and 2 weeks before we got an email that it was flipping to virtual. And then last year was the first year back. So I heard there was something like 3,500 people in attendance. So it was a great time.
And they were all at the bar at night, right? About 3,500 people came to the
Yeah,
bar. It's crazy.
about 15 rows deep. You know, you
Right.
you walk back to the elevator and your ears are still ringing. You don't realize how loud it is. And so, how many bags of swag did you get, Mark? At
I don't
Heckler?
know, but I came back with the flu, so that seems pretty typical for Heckerling, right? Why
Par for
don't,
the course.
why don't we get our takeaways up?
All
And
right, let me share my screen. Hold on.
absolutely. So every year at Heckerling, there are themes or takeaways that we see. And oh, great picture for kids, by the way. And
Thank you. Are we? Is it good? We got it.
yeah, let's go to takeaways.
All
And
right.
one of the things that's great about doing the annual Heckerling update, I've done 20 plus of these. Chris has been doing these with me for, I think, about 4 or 5 years now. You get to see trends. So it's not just that year's takeaway, but also trends that we're seeing happening. And I think the first one that I really want to focus on, one of the first takeaways, and this is something where I think the IRS came out strong this year. I don't know if I had seen this as a trend necessarily until this year. This is like, I think, really a this year takeaway. IRS seems to be targeting trust modifications, termination agreements, decantings, and we're going to talk about the CCA on this, Horvitz case. This seems to be a target area. So you're going to have to watch we love to do modifications and decantings. I mean, we do a ton of these, but this is something you're going to have to watch when you do, just to make sure there aren't gift arguments that are being raised, that could be raised. The other one we've talked about, this is a multi-year trend, probably the whole time I've been going to Heckerling, attacks on formalities. But one of the ones I want to focus on this year is timing. The timing issue is definitely a major issue. If you wait too late to do the transaction, if you don't separate elements, you're opening up your case to attack. And we've talked about Spaldino in the past. One of the big items, appraisals. Every year there's a case or a CCA where the case was lost on an appraisal. And either it's a not qualified appraiser, an out-of-date appraiser is creating issues. And John Porter, who does a lot of litigation on these tax issues, and he spoke at Heckerling this year. I'm going to mention him a couple of times because I thought his presentation was fantastic. He said some of the best money you could hire is really on the appraiser. And I think that that's true. And of course, Chris, the 800-pound gorilla in the room, the Corporate Transparency Act, just created this huge new reporting requirement that's really affecting the profession. Any other takeaways you think from this year's program?
Again, it's just we're focusing on those foot faults. I think that the IRS is getting a little frustrated with people playing games with estate planning, and there's always the higher scrutiny when we're dealing with intra-family transactions. So it really just goes to show you've got to cross every T, dot every I, and we also saw in Hohenshi, which you're going to talk about, a newer element with emails. We always know the specters there that emails are discoverable, and Hohenshi really put that issue front and center.
Absolutely. And is it my imagination, or does the IRS also seem to target charitable deductions sometimes?
Yeah.
And when we talk about Hohenschein, where they targeted the charitable deduction, the impact is so dramatic when you lose that charitable deduction.
Absolutely. All right. So with that as the backdrop, we'll start. You can't give an estate and gift update without talking about the new exemption amount. So this year we got a $690,000 bump. Each person has a gift, estate, and GST exclusion now of $13,610,000. So a married couple now has about $1.4 million of fresh, dry gunpowder. The annual exclusion has gone up again to $18,000. This was 3 years in a row, which I believe has got to be unprecedented. In 2022, it went up to 16,000, 23, it went up to 17, and then now we're back up to $18,000. And, you know, it's always that low-hanging fruit with a wealthy client with an already taxable estate. You always check that box of, you know, you got to be maximizing your gift tax exclusion amounts. You got to be maximizing the 2503E amounts, the direct payment for medical and educational. And just to, you know, illustrate it, let's say you've got an 80-year-old client. He or she's got 3 kids, 8 grandkids, and they're all married. And let's say your client's married too. In that case, you can give away gift tax free up to $396,000. So either those are outright gifts, or we can put them into an insurance trust to cover premiums. You know, you always just gotta, there is the gotcha that you don't get the GST tax annual exclusion for a gift into a crummy trust unless it's got, you know, specific, you know, requirements that abide by 2642C. But in any event, it's pretty powerful now that we're at $18,000. Everyone knows January 1, 2026, the sunset kicks in. The exemption amount, that base amount that was doubled to $10 million, that's going to go down to $5 million. So we're thinking it's going to be, you know, between $7.25 million and $7.5 million per person. So we have the use it or lose it situation.
Yeah, and one of the things we're doing, of course, is topping off the use of the exclusion, right? You have those people that grandfathered in prior years, and they're coming in this year, and they have another 690,000 to transfer into their slats and otherwise. So that's something to do. So potential estate tax legislation, I got to tell you, I've been to a lot of Heckerling presentations, and they used to spend a lot of time on predictions and potential legislation. And this year, there's very little discussion about it. A lot of it, the discussion was like, we're going to wait and see. Because I think what happened, Chris, is people got tired of predicting, and they were always wrong, right? There were always surprises and changes that people weren't quite expecting. And so they've gotten out of the prediction business a little bit. But let's humor me for a second. I'm just going to make some quick predictions here. I think we both agree nothing's going to happen this year. It's an election year, split government, nothing on estate tax regarding credits exemption is going to happen. We all know that. But what am I telling clients about next year? What's going to happen next year? And I think really there are 2 scenarios. One scenario is a Republican sweep, and I think the exemptions are going to be extended. That's one possible scenario. If you're putting me on the record, I think the more likely scenario is we're going to have split government. And basically what I think that means is it's going to be chaos, right? We're not going to know. We're going to have to plan that whole year. It's going to be a very intense year of planning. Chris, by the way, no vacations that year. We're going to be working all of 2025. And then I hate to say this, but I think they're going to do this to us again. And at the very end of 2025, they do like an extender. I've joked about the 1-year extender. But I think the reality of it is that you can't wait around and wait to see what happens, other than if a client's super low on the exemption where it's close on whether they should do something, maybe they wait for the election results. But most of those clients need to start acting now. Chris, are you on record on any predictions?
I'm certainly not on record.
Well, do it now. It's being recorded.
No, I'm not predicting anything with the state of our government. No way.
Absolutely. So what should you be doing now? Like I said, we don't think you should wait. Let's talk about slats real quickly, because this has been a problem area. You know, we've created a ton of slats, but clients usually wait to the end, right? And they wait until late 2025. And in the prior years, it was right before the other cliffs. And we wind up doing 2 slats close in time together. And of course, we're worried about the reciprocal trust doctrine, and everyone's talked about that a lot, right? And you make changes between your 2 slats so they can't unwind them and say it's included in your estate. But what about the bigger issue, Chris, sometimes? It's the timing issue, right? It's the Smaldino issue. The clients need to use the joint account and transfer it into one spouse's name, and then they don't have enough time to wait to let it settle in that spouse's name. So that's a gift from the spouse and not from the joint couple. So the idea, the takeaway is, let's do a slat now in 2024, do one in 2025, right? Let's time these things out so we have clear differences there. What about some of the other ideas, Chris? Any thoughts on those, what we're doing to try to gear up?
Well, yeah, and just on the timing, and I know you're going to speak a little bit about John Porter's excellent presentation, but I know he went to the timing. I think this was with regard to a seed gift to support a sale to a grantor trust, but I think it, you can analogize it elsewhere. And he said, if I'm in an audit, I want to see 30 days. So you make the gift, you wait 30 days, and then you sell the asset. To a let it cool off, let it bake a little bit. So, what do you think when you're breaking a TBE, for example, and you're going to create a slat? How much time do you like to see in between breaking the TBE and resting in the grantor spouse's account?
It's like I could analogize this to like change of domicile, where I don't just want 6 months and a day, which I think is the 30 days. If I can get 60 days, that's what I want. Something like that, a little bit longer of a time period. But of course, you're taking away the asset protection, right? By breaking TBE to transfer it into the slat. So if I could get 60 days, that's better. But the problem with these transactions, when everybody does them close in time, they're doing these transactions within, a couple of days, and then or maybe the same day, and then you're bringing up small Dino where the IRS could collapse it and say you transfer to your own slat, creating all kinds of issues.
Mm-hmm.
What about these shelf techniques? Any thoughts there as far as creating things now that we have them ready to go so we can move at a moment's notice?
Yeah, I like the idea of the shelf trust because, there are times when, you're up against a deadline with a client and unbeknownst to you, the client is in Mexico or in Israel. And you say, I wish you would have given me a heads up. We really got to close this transaction or this trust, and I need a notary or, and two witnesses. So I like the idea of having an irrevocable trust, have it signed with the witnesses and the notary, and just have it sitting there, because you can do an assignment of an entity interest, for example, with DocuSign. You don't really need to have all the formalities. So that's why I like shelf trust, just for sometimes the lack of reliability of the client. With the actual, so that's the the receiving trust. With the assets themselves, I really like the idea of wrapping them in an entity like an LLC. So when you have to move and transfer it, it's a simple assignment. It's a one pager. I transfer 15% of Weeg LLC to the trust. I think that's simple. We've been up against, you're trying to transfer rollover equity, and you've got to go to the PE firm and then deal with the big law firm and trying to get them push it through and explain to them what an irrevocable grantor trust is. And 3 weeks later, they say, okay, you can transfer it. So I definitely like the idea of wrapping it in an LLC to simplify transfers.
Absolutely. I wonder in 2025 if you might have some banks and institutions say, we're not making any more transfers after a certain date, it would just be overwhelming. So having these entities ready to go, is the move. Although you're going to talk about it, Chris, they're going to have to do a CTA report, right? They form that shelf LLC or the funded LLC. They got a new reporting requirement. And then, of course, the one we've talked about a lot is sale to the defective grantor trust. You have a note ready to go, and then you could forgive that note at a moment notice. You don't have to involve the bank or any other institution. Really, would just get rid of that note, and that's the gift. So that's obviously really helpful.
And then the added benefit with the sale is, if you're dealing with a closely held interest or anything like that, you can sidestep any 2036 arguments as long as it's respected as a bona fide sale. So it's
Hey, Chris, you just reminded me of something John Porter said about that with the note. He said the IRS is actually making an argument, and I think I've heard this before, that when you have that note, if the entity makes distributions that you sold, timing it directly to pay off that note each time, maybe they could start arguing 2036. So there's always a little opening, right?
Yeah. All right. So next one, the Inflation Reduction Act. So the only reason we're talking about this is because John Porter brought it up. And this was the act that passed in 2022, where the government was going to spend $1 trillion of our dollars, and somehow that was going to reduce inflation. So there you had the important takeaway. There was $80 billion was allocated to the IRS, and that made a lot of news there. Frankly, as tax practitioners, in some regard, it's welcome. In that we'd like a a functioning IRS. And John Porter, brought up and said, we're seeing, some of that additional funding in an uptick that he attributes to the Inflation Reduction Act in gift tax and estate tax audits. So, the money did go somewhere and it's being spent on apparently audits.
But still no 1041 audits, of course, right? Those never seem to happen.
No, that's the mythical 1041 audit.
All right, let's get into, I think, which is probably the biggest case of the year. And even though this is a loss, the taxpayer lost this case, I still think it's a very valuable case. One of the reasons it's so valuable is because sometimes it tells you just what not to do, but also if the client or another planner or somebody else involved in the team is pushing an idea like, oh, we don't really need to have a qualified appraiser here. This person can do it. They've done a few. Yeah, you could send them a case like Hohenschein on that kind of issue. And I think it's really been helpful. Chris and I talk about sending out these kind of cases sometimes. Hohenschein, Smaldino, the CCA on Gratz could be very helpful to get the group, focused in on the right formalities and getting the qualified appraiser. So let's go into the facts. The facts here are important. Mr. Hohenschein and his two brothers own this business. The brothers are important because you get into a situation where Mr. Hohenschein is worried about diluting his interest relative to his brothers. So even though he wants to give away an interest, he's worried about the brothers' involvement. Now, sometimes we'll talk about recapping the company. So even though you're giving away something, you're maintaining the voting interest, but they weren't doing that there. And then the second fact, the second bullet point is important because they get an LOI on April 1st of 2015. Now, I don't know about you, Chris, but too many of our clients seem to wait until they get an LOI. They're like, oh, I haven't signed it yet. But they get that LOI in the mail and then they're ready to start doing the transaction. And really, that's when a lot of people are motivated. We want to do it well before that time. And then, of course, here's what you were talking about before. There's a lot of damaging internal emails. And you could almost go through a Hohenschein case, just quote the emails, and you'll see why they're so problematic. And now a lot of these emails are between the client and the attorney. So you just have to remember in these cases, a lot of times you're going to waive attorney-client privilege to have the attorney testify about the purposes and the reasons. So a lot of times these emails come out. And so at inception, you have to plan for the audit at inception. And if you get a problem email like what's happening in this case, you need to deal with it. And sometimes I've called back the client and said, wait a minute, let's talk about this. I'm going to respond to this email. I want to put some more issues out there, but let's be careful what we're putting in emails because this becomes part of the permanent record. And I think there was a mention that in a recent case, 1,500 of the 2,000 exhibits were emails. So that just shows you how important these things are in the case. Let's go to the next slide. Let's talk about one of the emails that came out. You see, Anne, they want to wait as long as possible to pull the trigger on the gift to the donor advised fund. And here's exactly what's happening in this case. They're worried about, they want to wait, the client wants to wait as long as possible, taxpayer wants to wait as long as possible, and they're worried about dilution relative to their siblings. So that's a major problem. And then April 23, they sign a non-binding letter of intent. So let's keep it in mind, they haven't done any of the planning yet, but they've already signed an LOI and there are already these emails out there about their intent. Let's look at the next one. More things about the facts because the facts are so important. Chris, that email on June 1st, I honestly don't know what I would do if I received this email from the client. I do not want the transfer of the stock until we are 99% sure we are closing.
At least he didn't say 100%.
Right. It's still,
he gave you a little bit of wiggle room there.
There's a little wiggle room there. And then then they signed a consent on the number of shares on June 11th. The board signed a consent to the amount of shares. Well, not the amount of shares, the idea that shares were going to be transferred, but they never said how many. So now here are really, I think, the key dates, right? This becomes the key dates in the transaction. July 13th, the stock certificates are signed and transferred to the donor advised fund. And then on July 15th, they sign the purchase agreement. So what they're trying to do is have that money moved over to the foundation, get a charitable deduction, not report that income. Now, here's the thing. When they report it on the return, they report it as June 11th. Now, Chris, why did they pick June 11th? It seems to me kind of clearly under this case, the gift seems to have occurred on July 13th. Why did they try to pick June 11th for the appraisal?
Well, I think to avoid the anticipatory income doctrine, to say,
Right,
hey,
they're trying.
it's done a month early.
They're not thrilled about the timing, right?
Yeah.
They're a little worried about anticipatory assignment of income, and they're like, let's say this was June 11th. So that's going to be a problem. And then they also have an appraisal prepared by the investment banker instead of a typical qualified appraiser like we have, who are sponsors of the tax section, like Roy Myers at MPI, Tim Bronze at BVA. They didn't use those qualified appraisers. They used the investment bank problem. Those are some glaring red flags, right? Oh, and then the other one, just for fun, the appraisal company used a higher value for the donation than what they sold it for. That is going to anger the IRS and I think courts. You don't want to do that. So that's what happened, unless you have great data to support it. And when you don't have a qualified appraiser, probably going to have great data to support that.
Well, a lot happened between June 11th and the sale.
Exactly.
They sucked all the money out of the company, if you read the opinion.
Right. That's
why.
Right. So that's why the value went down. That's exactly right. That's why they wanted the appraisal on June 11th, maybe. I don't know. All right. So let's go through some of the issues. When did the gift occur? And I have a general philosophy that if you're having one of these cases about anticipatory assignment of income and deductions, you don't want to have a dispute over when did the gift occur. You should know. You should have your formalities in place when it's clear when the gift occurred. And I think the court pretty easily decided that the gift occurred on July 13th, when you actually signed the number of transfers, number of shares you were transferring to the donor advised fund. This seemed like a pretty easy determination as far as I can tell from the facts. So July 13th, that's when the gift occurred. What about anticipatory assignment of income? And I think what they said here is basically at that point, 2 days before the transaction, I know in theory, the donor advised fund still, had not signed off, like the deal was not completely done. The court basically said, this deal was done. This thing was 100% done. There's no risk at that time that it wasn't going to happen. And they said, no, anticipatory assignment of income, taxpayer pays the income tax, not the donor advised fund, which wouldn't pay any income tax, right? And so that's the first finding from the case. Let's go to the second one, the charitable deduction, because I think the first one was sort of hard to avoid if this is how they were doing the transaction, unless they were willing to do the gift a lot earlier, right? That's when they did the gift. I mean, it was hard. They were going to have to beat that issue back on the law. But the charitable deduction side, this is where you're not following, what's happening with the deductions and where the IRS is on these cases. So if you have a contribution over $500,000, you need to have a qualified appraisal. And one of the things that the court said is that we're not going to do strict compliance. We're going to do substantial compliance. But they said here in this case, you don't even have substantial compliance. And why is that? Number one, they use the investment bank to do the appraisal, which, by the way, you could have a qualified appraiser there, right? That's possible. But they said this one happened to not be a qualified appraiser. He didn't do enough appraisals. Even if you don't have the designation, they can still find you were a qualified appraiser, right? That's possible. They just said you never did a charitable deduction one, maybe you did an estate one. They said you're not a qualified appraiser. And by the way, Chris, that's the most important factor. So my question is, why even go there, right? Why even find out if this person's a qualified appraiser? No, you hire, my thinking is, don't mess around with this $3 million deduction, get the qualified appraiser. And then the other thing they talk about is that because of those timing issues, right? The appraiser said it was June 11th, but the transaction was actually July 13th. And they said the date could be a significant failure. So based on that combination, they disallowed the deduction, no charitable deduction in this case. And I think this one could have been an easy one to avoid, right? The assignment of income, the client, that was tough, but this one, you have to put your foot down, I think, sometimes and say, you got to get a qualified appraiser here. Let's not mess around. Let's look at takeaways. IRS is still attacking. This was a timing one, right? They're attacking timing issues. They're attacking appraisals. And if you don't have a qualified appraiser, if you don't bring the appraisal current to the date of the transaction, you might have a problem. And then, of course, watch what you're putting in emails sometimes, or at least let the emails reflect the entire record, I would say. Just because the client's looking at the tax issue, maybe that's top of mind. Maybe there are other issues that also need to be discussed in that email. Chris, any other thoughts on Hohenscheid before we go on to Schlapfer, which is a great taxpayer win?
Hohenscheid, that opinion, as I read it, made me queasy. Going through the emails, the internal firm emails between the estate planning lawyer and the corporate lawyer, and then, the appraiser issue, which really came from the estate planning lawyer saying it'd be more efficient to use the bank. It's just, that was a bad one. So Hohenscheid was a classic case, bad facts making bad law. So you've got to sit here on an audit and explain to the IRS, you say, hey, my guy ain't Mr. Hohenscheid. That's a problem. On the flip side, the case I'm going to talk about, Schlapfer, is a case where bad facts make good law. You had some of the worst set of facts here resulting in a taxpayer win. So, Schlapfer is definitely not a how-to, start the statute of limitations. But, sometimes when you get brought in on a cleanup job, this is where Schlapfer really shines to show, listen, at least my guy did more things than the Schlapfer guy, and he started the statute of limitations. And, in the office, Mark, when we get a bad case in, we call it a dog. When we have a really bad case, we call it a dog with fleas. I think with Schlapfer, if this came through our door and we were helping on the audit, I think we'd classify this as a three-legged dog with fleas and long COVID. That's how bad this one was.
That's bad.
So it was bad. So, here was the issue. The issue was whether the gift tax return started the statute of limitations. Just as everybody knows, you got 3 years from the later of filing the gift tax return or the due date of the return for the statute. If it's not adequately disclosed, the gift, well, then the statute remains open. So turning to the actual disclosure requirements, just as a refresher, now these are contained in the regs. So they're not in the code, they're in the regs. So these are requirements, they're not rules. And that distinction is important because the judge, went into that, and I thought it made a lot of sense. So you want to describe the gift, the consideration received for the gift, if any, the identities and the relationship between the transferor and the transferee. If the gift is in trust, the tax identification number and the terms of the trust, or you can attach the trust agreement, of course. You want to, and this is an important one, the detailed description of the method used to determine the fair market value of the gift. And that can be satisfied with a qualified appraisal. So basically, those are the main adequate disclosure requirements. And when I'm preparing or reviewing a gift tax return, I usually have that printed out. And particularly if I'm doing maybe a non-gift adequate disclosure and just checking and making sure we're hitting everyone. So, I want to strictly comply with it. But as we see in this case, substantial compliance will get you there. So here are the ugly facts. You got Mr. Schlapfer. He files a 2006 gift tax return in 2013 as part of an OBD, I always get the OBDP submission. So the return was filed just in a protective capacity. He was taking the position, look, I was not a U.S. person in 2006, so, these gifts weren't subject to tax, so he just wanted to, put that on record, start the statute. The gift tax return, again, a 2006 return, reports a gift of closely held stock to his mother. So we got the year is 06, the gift is stock, the donee is the mother. IRS comes in, and there's some technical, aspects of the opinion that we don't really need to go into. But the IRS says, okay, well, you screwed up on 3 levels. First of all, it was a gift of a life insurance policy that occurred in 2007, when, by the way, Mr. Schlapfer was considered a U.S. person, and the gift was not only to his mother but also to the aunt and uncle. So they said, well, 2007 gift, you never filed a return. Here we are in whatever year. Well, 2023 is when the opinion came down. You owe us over $4 million in tax and over $4 million in penalties. So a lot was at stake here. So the first question, the tax court had to address was, we've got these adequate disclosure requirements in the regs. Do you have to substantially comply with them or strictly comply with them? Tax court came down and said substantial compliance is sufficient with those requirements in order to start the statute of limitations. So they said, look, these purpose of the adequate disclosure requirements, they're to provide guidance to the taxpayer on how to start the statute under Code Section 6501, but they're not rules. Rules require strict compliance. Guidance requires substantial compliance, according to the Schlapfer court. So that's good. All right, Mr. Schlapfer, he's chugging along. He's got substantial compliance. Next question is, well, did he substantially comply? They went through each of the adequate disclosure requirements. The first one, description of the property. Now you think, well, gosh, our guy's in trouble. He reported stock, but it was life insurance. So the tax court said, well, it was stock, but when it really was probably the policy, but he complied because he provided enough information to describe the underlying property that was transferred. And again, the technical aspect here was that he transferred the stock to the life insurance company, which the policy then owned the stock. And I think he interpreted a rule that said, well, you should look through the policy and report the actual, underlying asset. So he tried. The tax court said, substantial. Next one, identity of the parties requirement. So you say, okay, well, this one's bad for Mr. Schlapfer. He said it was to his mom, but it was to mom and uncle. Tax court said, it's not that big of a deal that he failed to identify all the donees. He still complied because it was basically, we understood the gist of the gift, and that was to family. It was to mother and also aunt and uncle. So, the IRS said, hey, this was not fatal to, basically being on notice whether you want to audit this return that he missed the 2 other people. So next requirement, description of method used to determine the value. So, he didn't attach a statement or certainly a qualified appraisal of how he valued the gift, but he provided financial information, balance sheets, income statements, dividends, operating results. And it was enough for the IRS to be able to determine and say, okay, we know how you determine, the value based on these financials. And again, the gift was actually of the life insurance policy, but, again, extending more grace to Mr. Schlapfer, the court said, well, the policy owns the stock. You attach the financial information related to the company. That should be enough for the IRS to understand how you determine the value of the gift reported on the gift tax return. So taxpayer wins in this case. Takeaways here, the tax court was extremely forgiving in this case. Mr. Schlapfer, he didn't get the year right. He didn't get the actual transfer right. He didn't get the donees right. Not only that, if you read the opinion, they also essentially say, well, not all of this information, I think the financial information, it wasn't even, included with the return. It was included with the entire OVDP submission. So this wasn't even on the face of the 709. So, you see this case, and like I mentioned, this isn't, a how-to, but this is helpful just to know that, if you've got a bad set of facts and you're trying to do some cleanup, you've got some generous, substantial compliance, considerations in this case. Now, Mark, how do you think this case would come down, Schlapfer? And the judges were different, the tax court judges in Schlapfer and Hohenscheid. So what if we had Hohenscheid judge sitting on the Schlapfer opinion and vice versa?
I wonder if they would have come out completely opposite. You could read both of those cases on ways to get to a result where the Schlaffer judge maybe would say, no, you didn't have a binding purchase agreement in place until, that date, till the 15th, and I'm going to let that work. And then on the charitable deduction, they've been a little stricter, but I could see substantial compliance if the value was close. And then, of course, the Hohenscheid judge here, I can't, I think they might go the other way. I think the Hohenscheid judge probably wouldn't have found that you met the adequate disclosure, is my guess. I don't know. What do you think, Chris?
I tend to agree, but I think if you had the Schlapfer judge on the Hohenscheid substantial compliance on the appraisal, I think Mr. Hohenscheid, meets substantial compliance with not, you may not have had a qualified appraisal, but surely the appraisal that wasn't qualified provided the IRS enough information to determine how you came up with the value, even though it wasn't prepared by MPI or BVA. But who knows? It's just this is a good case now, for us to be able to reference.
And if the IRS is trying to open up a statute of limitations longer than what's provided, you send it to them, and I'm sure they're going to say we're not following that, but we're still going to send it to them, right?
Absolutely, absolutely.
They don't want to follow the good cases, right? It's like the laundry case; they still have non-acquiesced to that.
Mm-hmm.
Let's talk about a CCA, which is a big deal that came out right before Heckerling. And the IRS is definitely trying to make a point with this CCA. And this is a line that we have, a line of information that's come out from the IRS that we can definitely take some lessons from. So what happened here? You have a typical defective grantor trust, irrevocable grantor trust, completed gift. And we're like, these things are fantastic. They're the bread and butter of estate planning. And one of the things we tell the clients is, what's even better about this transaction we're doing where we're freezing it and taking discounts? But guess what? You're going to pay the income tax on this transaction. And even better, that's a tax-free gift to the kids. So it's just shifting a tremendous amount of wealth. Now, when we do these documents, we typically build in the discretionary right to reimburse the grantor for taxes, because sometimes they get tired of paying the taxes, or sometimes the transaction hits so big that you could bankrupt the grantor, right? So the ability to reimburse the grantor is potentially very important. Now, this particular trust did not have a reimbursement provision and was not in a state like Florida, which would allow for reimbursement even if there's not a provision in the document. So what did they do? You had created this discretionary trust for the kids and their issue. Everybody got together. They did a judicial modification of the trust and added a discretionary, not a mandatory right, just because you can't add that in without creating problems, a discretionary right to reimburse the grantor. So let's see what the IRS says about this on the next page. All right, look at these positions. So they start off saying that that's a gift. Adding in that provision that you could reimburse the grantor for taxes is a taxable gift by the beneficiaries back to the grantor. Now, I don't know if we would have necessarily thought that was the case because we're allowed to include these provisions. And in the past, there was a PLR that said they can do this. Oh, by the way, as I referenced in the last bullet point there, the IRS changed their mind on that PLR. So keep in mind that a PLR is not binding on other taxpayers, not binding on the IRS. It's just as to that taxpayer. So be a little careful when you just rely on a private letter ruling. But let's go back to bullet point 2, because there's a couple of really important things they say here. And this is one thing that I've heard bothers the IRS. You still have a gift, even though it's difficult to figure out what the gift is. Even though a lot of times you'll hear people say, well, discretionary beneficiaries, discretionary right and reimburse. What is that? What could that be? And they say, just because it's difficult to calculate, it's still a gift. I don't think that's breakthrough, but it is something I think that bothers them. And now is where the IRS starts really throwing what I would consider haymakers. They're really trying to scare now. The next thing they say is that, well, if the gift is not susceptible to valuation, sometimes the gift is the whole thing. By the way, this is a cite to a Treasury regulation. This isn't something they made up. So they're trying to scare you and try to come out and say, no, no, it's not just a little amount that maybe it is. Maybe it's the whole thing. And then they come out and say another thing that's designed to scare you a little bit. And they say, by the way, they throw this in there because they didn't have to. They said the result would have been the same, even if what happened here as a result of modification was it was a notice and then a right to object, and the beneficiary failed to object. So what are they trying to get to? Things like decantings, possibly. They're trying to broaden the scope and make you a little bit more scared. So let's look at some takeaways here. Obviously, what they're trying to do is have a chilling effect. And by the way, they're trying to have this chilling effect. The CCA is not precedential. It's their litigating position. And I don't know about you, Chris, but I could see them losing this case, right? But until they do, it tells you some lessons, of what you have to worry about. Now, one thing I think people are going to do as a result of this CCA is we're less likely going to ask for consents, right? Because that argument that you had a right to object and you didn't, a lot of people say that's going a little bit too far. And you feel a little bit better on that kind of case. So maybe when you're doing it, maybe we're doing the decanting, but we're not having everybody sign off on it, where the gift argument is a little bit stronger. Those are the kind of things that we're thinking as a result of this CCA. Any thoughts on the CCA, Chris?
I just found, one of the scariest things was that, they'd say you'd still have the gift if the beneficiary basically slept on their rights and didn't object. I think just putting the onus on the beneficiary to, either file a lawsuit, engage an attorney to stop something like this, and the practicalities too in a situation like this. So if the beneficiary challenges, let me tell you, that beneficiary is cut out of A's estate plan, guaranteed. So I think this is a wish list. I think they lose, in litigation, but this was coming out just saying, hey, this is ticking us off, and this is at least what we'll take, I guess, in an audit. But I found it really scary.
I think you're going to have to have closer scrutiny when you're trying to mess around with, like modify trust, terminate trust. Let's think about terminating trust. We're going to try to give out all the money under a HEM standard because we want to accomplish certain results and have the beneficiary sign off and get this all to the the surviving spouse or something like that. And we'll talk about a little bit on that front. But any of those kind of things where you're trying to do that kind of result, I think that raises a lot of strong gift issues to be concerned about. So I think this is my takeaway from this CCA is really, this is an area of interest that they're targeting, and maybe raise the game a little bit on when you're working on these transactions to limit the gift issues. Let's go to Horvitz, because this was a docketed case. This wasn't a court. There was no decision that came out of it, but I think it's important because it's once again the IRS targeting a decanting and targeting a charitable deduction. And so what happened here, you had a surviving spouse in a Q-tip trust, and there's always a lot of planning that's attempted with Q-tip trusts. And they said, all right, we want to get some money to charity, so let's decant this trust and increase the scope of the testamentary power of appointment. And then what happened was the spouse exercised that testamentary power of appointment to give $20 million to charity. Okay? And then they actually gave the money. The surviving spouse passed. The money was given to charity under her document. And the IRS attempted to deny the charitable deduction. So when you first hear the facts, you're like, well, what's going on here? This seems like, bread and butter planning that we do all the time. What's happening here was that the IRS was trying to say that, the fruit of the poison tree, basically, that because you didn't have a valid decanting, you don't get a charitable deduction. They were trying to go back and say the decanting was bad and therefore no valid charitable deduction. Well, how is the decanting bad? And what they try to say is that under Ohio law, they had a general welfare best interest standard. And the way the statute was written, they thought it had to say absolute discretion. They were trying to argue that. And we know under Florida law, there would be no argument there, right? Our statute clearly makes that happen, that's absolutely, best interest is fine. But they were trying to make that argument under Ohio law. And I think what happened was they felt pretty good about it until the court started issuing orders. And then they're like, all right, we're going to lose this case. Let's back away. But it shows they're looking at these decantings, looking at modifications to see what they could, what they could come up with. Let's go over to the takeaways, because I think most of them I mentioned, but I really want to mention the last bullet point, the CCA there from a couple of years ago. And this CCA 2021-18008 is actually now the McDougall case, which was talked about by a couple of presenters during Heckerling. And so this is very important to know about, because when you're dealing with Q-tip trust where you have a marital deduction, you got to be really careful what you do with that trust, because there's a code section 2519 that a lot of people aren't as familiar with. And what that code section says is that if you dispose of the income interest at all, then by disposing of that income interest, you've made a gift of the entire remainder interest. So just to illustrate it, what happens in this case, the CCA, which became the McDougall case, there was a $117 million Q-tip. And they're like, oh, we got to do some planning with this during the surviving spouse's lifetime. Otherwise, $117 million is going to be included in their estate, plus the growth, right? That's going to be a problem. So they did a commutation agreement, and all the money wound up with the spouse so she could do planning, right? And I think they were hoping nothing, that's neutral. Nothing happened, right? It was going to be included in her estate, got it over to the spouse through a commutation agreement. The IRS says that, no, what you did was two gifts. One gift was when you terminated this, you had a disposition under 2519. That triggered a gift of the entire remainder by the spouse. So the spouse owes us $47 million plus of gift tax for that. And then, oh, by the way, the remainder beneficiaries, the kids, by consenting to give the money back to the spouse, they also made a gift and they owe us $43 million. So while nothing happened, we're asking for $80 million. And just to make it fun, I guess it's triple tax, right? Because now it's back in the spouse's estate. Now they're planning with that asset, and I think they did some sales. So it's like triple taxation in this case. And Chris, isn't this something where, first of all, I don't know how this is going to play out. Probably be a reported decision eventually on this case, is my guess. But we're starting to see some things where the IRS is trying to say, we can make arguments where we're getting more than the whole, right? We're not just getting the tax. There's other arguments where we could accrue extra penalties, essentially. Not penalties, but valuation issues or reasons why there's more gifts happening back and forth. Haven't we seen that in other areas?
Yeah, you've seen it in Estate of Powell and Estate of Moore with the double inclusion under 2043, where you've got if 2036 applies, you've got the phantom inclusion of the partnership assets. Now, of course, under 2033, generally, the partnership interest is includable as well. So both are included because nothing says you don't include both. And then 2043 comes in and says, okay, well, you'll get a difference based on essentially the value of the contribution, the consideration offset when you created the partnership. So to the extent you have an old and cold partnership, which you did not have in Moore, so it was almost academic. They said, well, this is the result, but it doesn't matter. But if you have an old and cold partnership, you're going to have, basically what you're saying, Mark, more tax than you can ever imagine. But I like the Mark Brown argument, which is, yeah, but nothing happened. You could say, hey, we commuted the Q-tip, and somehow I have an $80 million tax bill between the two sets of parties. But I don't think that one's going to work, Mark, that argument.
Well, basically, I think what you try to argue is that I didn't make a gift under 2519. It came back to myself. Why are you triggering it? But I think the takeaway really is you have to be extraordinarily careful planning with marital deduction trusts because of Code Section 2519. You need a different path to get to that result. Best interest distribution, maybe, but that could be another presentation.
All right, so I think based on timing, we can bring it home with a quick CTA discussion. I know everyone in the tax section is familiar with this and has heard a lot of speeches on it, so we'll be brief here. I just want to point out. So again, it's Corporate Transparency Act. This is the new regime of beneficial owner information reporting, filing these reports with FinCEN. I think it was a couple weeks ago, or maybe a month ago, New York came out, not to be undone by the feds, with its own state level version of the CTA. So I assume, other states will follow suit there. This is a massively expansive program. It targets a reporting company, which is basically every domestic company, corporation, LLC, anything that files essentially a formation document with the Secretary of State. Same with the foreign corporation, so anyone that's doing business and files, some sort of document with the Secretary of State. We've got an estimated 32 million entities out there that are going to, be reporting under this regime. Now, there are exemptions, 23 of them, large operating companies, inactive companies, highly regulated companies. Basically, for not a lot of clients like ours on the estate planning side will qualify. A lot of times it's going to be, grandma with a single member LLC and a rental real estate will not qualify for an exemption and will be on the hook for these BOI reports. As far as what we're reporting who a beneficial owner is, and beneficial owner comes in two flavors: someone who exercises substantial control and someone who owns at least 25%. We don't really have time to go into, what that means, but just know, those two factors. Questions posed up, well, what about a trust? Can a trust be a beneficial owner? And the answer is, well, sure, all three parties to a trust could be a beneficial owner. The trustee is the person who has legal title. So if they have legal title to 25% of an entity. The beneficiary, if they're the sole permissible beneficiary of income, if they have a right to demand distribution. The grantor, someone with the power to revoke, a grantor with a retained revocation. So question, if a grantor has a retained substitution power, if that qualifies, what do you think about that, Mark?
Yeah, I'd report that until further guidance. Why not? Yeah, I think that's what my approach is to report if we're unsure.
Agreed. So, that's the kind of the trust rundown. You've got the company applicant. The interesting part here, the shift when we went from the proposed regs to the final regs, was that the company applicants were only going to need to be reported on a go-forward basis. So for those entities filed on or after January 1, 2024. We won't go into what's in the report, but what I will say is, talk about is when we have to file. So if you're a new reporting company, and any that's formed on January 1, 2024 and before January 1, 2025, you've got 90 days from registration. If you were an existing company before 1/1/2024, you got to file by 1/1/2025. And then after 1/1/25, any company formed then has 30 days to file their BOI report. And the last point, as far as updating it, now remember, these aren't annual reports. You just have to file it initially and filing it when you change it. So when you make a change, you've got 30 days to go ahead and file. So it really, I think the last is kind of a rhetorical question of who's going to be in charge of helping the client with this? Is it the lawyer? Is it the CPA? Is it another advisor who's going to say, look, you've got these requirements and you've got penalties of up to $10,000 and 2 years imprisonment.
Absolutely. I think there's a lot of discussion on who's going to be doing these reports, and some CPA firms I've heard are saying they think it might be unlicensed practice of law. I don't know how I come out on that, but it is something that's being raised. So there's a lot of questions on who's going to do this incredible amount of work.
All right. So you want to turn it over to Jennifer? I think our time's up. Jennifer,
any questions out there?
Let's see. I'm checking on my end. I'm not seeing any questions open. I just have to say that was a fantastic presentation. Thank you both. Lots of rulings that came down that have the probability of affecting our practices. So just a fantastic overview. Thank you both. I do want to give the CLE code, course code. Again, I said I'd give it at the end. It is 8206. Again, it is 8206. And just want to check to make sure there are no questions that have come through. I believe the slides have already been shared. And we've come to the end of the hour here. So seeing nothing further, thank you both for your update today. And we're grateful to have you.
Thank you.
Thank you.
Oh, we had something pop in.
Oh,
Okay.
I was just about to click leave.
Oh, what is a CCA?
What?
What's
Was
a
the question-
CCA? It's a Chief Counsel Advice Memorandum. So it's basically if you're on an audit, so you send a question up to the mothership for an answer.
It's their litigating position, essentially. So it's not binding on the taxpayer. Tells you, though, what they're thinking and what they're arguing. Okay.
Thank you all.
All right.
I'm gonna click now. All right.
Okay. Bye-bye.
Thank you.